every Sunday at 2 p.m. We ask you to tune in to the live show, and that is a live broadcast on YouTube. We come to you live every Sunday at 2 p.m. discussing, answering all your queries in regards to legal matters. So kindly come over every Sunday, tune to Law School Made Easy, a live broadcast where you get to interact. We have an interaction. You send your questions where you think you have a challenge, and then we shall be able to throw some light or make you appreciate some of those concepts. And today we want to discuss sale of good. And under sale of good, I am going to discuss section 13 of the sale of good, which clearly says that an implied term as to title. So under a contract of sale, what do we mean but there is an implied term as to the title? That should be section 13 of the Sale of Good Act. Now, this word implied term as to title. Now, when you enter into a contract of sale, now there is an implied term that the seller should be the person with the right to sell, that the seller has the right to sell a particular good. That if a seller does not have a right, a title, then is going to actually get issues or problems, because the buyer can repudiate the contract there and then seek for damages for having wasted their time. So when we say an implied term as to title, it means that on the part of the seller, the one who is selling a good should be having the right to sell that particular good. That at the time the property passes to the buyer should be getting a rightful title. If there is any query or any third party that may be involved in this transaction when we are formulating the contract of sale, then that must be disclosed at the time when we are making the contract of sale. Because the moment it is disclosed, then the buyer will know that I have bought this, but there is an issue which we must clear. So at that way, on passing on the good, then there the buyer will be confident that he has bought a right thing with an encumbrance somewhere. So that is what we mean by implied term as to the title. That you, the seller, you must be the person who is supposed to sell. You have the right. And this comes at play. Colleagues, take note. This comes at play. The moment when we are passing the property, you are now handing over, you have made a contract of sale, but now it's time for you to hand over the property. The moment you give, we assume that you are the right person, you have the rights, you have the right title, and therefore the buyer has received a good title from you. Let's take a case of Roland versus Dville. Now, in the case of Roland bought a car from Dville. Now, when he bought this car, he stayed with it for some time, but he did not know that the car was stolen. So on the third party coming demanding for the car, so the issue went to court. And then now they were determining, did the seller Dville have a title? Was he the rightful person to sell that car? So court established that the seller did not have the right to sell a stolen car because the car was not his. So he sold the car which was not his. So court awarded damages. But in awarding damages to Mr. Roland, Dville was arguing that let us remove the time that the buyer had spent with the car and then we pay the other damages. Court said no, we are giving him all his money. We are paying him because he had suffered the loss. He bought thinking that he has bought something from the rightful owner. But even you had stolen, and now there is a third party appearing. So we are saying, had the seller in this case disclosed that maybe the car is not mine when we are buying, we would not come to this problem. But he did not disclose, and he did not have the right to sell. So implied term as to title means that the seller is the rightful person who is selling that particular good or property. Now, for you to be able to know some of the elements or guidelines of an implied term as to title, one is quiet possession. Now, the buyer must enjoy quiet possession. That the moment you buy some good from someone, you must enjoy that good. There should be no one that is coming up telling you, this is what I need, this, bring my good, you stole this. You should have quiet possession. Enjoy that good. Then the other one and the last one is there should be no encumbrances from third parties. All the goods should have no any encumbrance. That don't sell, for example, in the case of Roland, they are selling something which is stolen or something which is a mortgage, but you don't disclose that this thing, this good is being put in at bank as a mortgage, as security. Okay, so that is, the goods should be free from encumbrances. That is when we know that the seller had a good title. When the buyer enjoys quiet possession, when the buyer takes on the goods which are free from any encumbrances, then we know that the seller had a good title. The seller had the right to sell the good to the buyer. So that is how you go about what we call the implied term as to title. That the seller must have the right, should be the rightful person to sell that particular property or good. So that is how you go about an implied term as to title. So we have so far discussed, I have separated them, not done them at once. We have done sell by description, and now we are doing an implied condition term as to title. And then we shall come back and do a sell by sample, and then also we shall do fit for purpose and very many others. So we thank you so much for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, like our videos. Until next time, thank you so much. Cheers.